James Egan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Ms. Nelson and Ms. Spengler, and the people are represented by Mr. Orman, Ms. Pearson, Ms. Stitch McGuire, and Mr. Edson. We are outside the presence of the jury. I appreciate everyone's patience. This morning I was finishing up a draft of the instructions. I thought it was important to share that with you this morning and to have a discussion about them. I'm not going to expect you to have a response, obviously, because you're just getting them now. This is a draft, and I have marked them as a draft, and I will make them part of the file so that the record is complete. The instructions are not complete. There are some instructions that are still missing, but most of the instructions are included in the set, and I thought that it would be helpful to have the set here with us as we discuss instructions. Before we do that, though, I want to take up a couple of issues. Number one, it's my understanding that on Monday there was a hearing held in Division 207 in front of Judge Antrim. And that was at the defense's request because there was a witness who had been subpoenaed for Monday, June 22nd, and the defense had requested a hearing so that the witness's subpoena could be continued. And Judge Antrim was kind enough to agree to preside over that hearing. My understanding is that Ms. Spengler was present and Ms. Stitch McGuire was present. It's also my understanding, Ms. Spengler, that you waived your client's appearance at that hearing. Is that correct?
That is correct.
All right. I wanted to make sure of that. My understanding also is that the witness apparently failed to appear. Is that correct?
That's correct.
All right. Any further record that you want to make with respect to that hearing, Ms. Spengler, or any requests that you have at this time?
No, not at this time.
All right. Great. Anything from the people?
No, not doing it. Thank you.
Okay, great. All right, Mr. Holmes, I need to give you an advisement at this time, and so I need to speak to you directly. If there is anything that I say to you that you do not understand or that you do not hear clearly, you need to please let me know that. You have a right to testify in this case. If you want to testify, no one can prevent you from doing so. You may take the witness stand and testify, even if it is contrary to the advice of your attorneys. If you want to testify, no one can prevent you from doing so. If you were to testify, then the district attorney's office would be allowed to cross-examine you. And you have seen how witnesses have been cross-examined thus far by your attorneys. When your attorneys call witnesses, then the prosecution will have an opportunity to cross-examine them. Similarly, if you were to testify, the district attorney's office would be allowed to cross-examine you. If you have been convicted of any felonies, the district attorney would be entitled to ask you about those convictions and thereby disclose the convictions to the jury. If any felony convictions are disclosed to the jury, I will instruct the jury that it can consider them only as they bear upon the issue of your credibility. I would instruct the jury that it cannot consider any felony convictions that you may have for any other purpose. I'm going to ask the district attorney's office at this time if any of the attorneys representing that office is aware of any felonies of which you have been convicted.
No, Your Honor, we're not.
And so as far as you know, he has not been convicted of any felonies. Is that correct?
That is correct.
Mr. Holmes, in this case, jurors have been permitted to submit written questions that they would like to have asked of witnesses. And you have seen the procedure that we have followed throughout the trial when witnesses are testifying. And you have seen that at the end of each witness's testimony, I have allowed the jury to submit questions that they would like me to ask the witnesses. And you need to know that the same rules of law, including the rules of evidence that apply to attorney questions, also apply to juror questions. The court will not permit improper juror questions to be asked of a witness. If you decide to testify in this trial, and if the jury submits one or more questions that the court determines are legally proper based on the rules of evidence and other applicable rules of law, then the court will ask you those questions, and it would be the same procedure that we have followed with respect to other witnesses. I mentioned a moment ago that you have the right to testify in this trial, and I have discussed that right and the consequences of taking the witness stand and testifying. I need to inform you, Mr. Holmes, that you also have the right not to testify in this trial. You are protected by a constitutional provision against self-incrimination. Therefore, you do not have to testify if you do not wish to do so. If you choose not to testify, then the jury may be instructed about that right. In fact, will be instructed about that right. The jury will be instructed about that right, and that no inference of guilt can be drawn from the fact that you choose or that you chose not to testify. The instruction that I have in mind that I am planning to give the jury is as follows. This would be the instruction that I would give the jury if you choose not to testify. Every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. It is not evidence, does not prove anything, and must not be considered for any purpose. The decision of whether or not to testify is a decision that must be made by you and by you alone. In other words, it is a personal decision, and you're welcome to discuss with your attorneys whether you wish to testify or whether you wish to not testify, but ultimately, it is your decision. It is a personal decision. In this case, you're being represented by multiple attorneys. You're being represented by Mr. King, by Ms. Brady, by Ms. Nelson, by Ms. Higgs, and by Ms. Spengler. And Ms. Nelson and Ms. Spengler are both present here today. And so if you wanted to discuss this with them, I would encourage you to do so. But again, in the end, ultimately, this is your decision. Mr. Holmes, do you understand the advisement that I just gave you? Do you have any questions about the advisement that I just gave you? Yes.
Your Honor, we would ask that we be able to
I'm not going to ask him that yet about a decision. I'm just asking if he understood the advisement. And what I'm intending on doing is just providing the advisement today and then returning to this issue at some point in the future after the defense has had sufficient time to speak with him and after Mr. Holmes has made a decision. So I wasn't going to ask him if he has made a decision yet.
I understand, Your Honor, and I would ask that I be Holmes and so
Well, he just said he understands, so the request is denied. I asked him if he understood the advisement. He said he does understand the advisement. The question is whether he has any questions for me. Do you have any questions for me, Mr. Holmes? No. Okay. Do you understand your right to testify and the consequences of taking the witness stand and testifying? Yeah. Do you understand your right to not testify? Yeah. All right. Any other record that the prosecution wants me to make at this time?
No, Your Honor, thank you.
All right, thank you. What we will do is then we will come back to this at some point in the future, and I will ask at that point whether Mr. Holmes has had an opportunity to discuss this with his attorneys, whether he's had enough time to do so, whether he needs more time to talk to his attorneys about this matter, and if he tells me that he has had enough time and that he has talked to the attorneys to the extent that he wishes to do so, I will then ask him whether he has made a decision about whether he is going to testify or to not testify in this trial, and then I would ask him what that decision is. But we will defer on that for now. We will come back to it. And I'm likely to go through, I may go through the entire advisement again just to be sure that Mr. Holmes is still clear on his right to testify and his right to not testify. But at this time, I find that he understands the advisement, that he doesn't have any questions about it, that he understands specifically his right to testify in this trial, and that he understands specifically the consequences of taking the witness stand and testifying in this trial, and finally that he understands the right to not testify in this trial. Okay, with that then, let's move on to the jury instructions.
Your Honor, I'm sorry, if I may.
Mr. Edson, yes.
Judge, I've received an email from your clerks yesterday about the Hotmail, and I have an answer for the court if the court wants to hear that now.
Yes. Why don't you tell me exactly what you're referring to, please?
Thank you, Your Honor. Judge, last week, the court and jury heard testimony from regarding Hotmail emails, and the exhibit, the tendered and admitted exhibit is 347A. And the people also admitted two different CTR exhibits, CTR-73 and CTR-74. Those make up tendered to the court Hotmail emails, however, non-admitted emails for various reasons, hearsay and other such reasons. I received an email yesterday from Your Honor's clerks indicating that the CTR exhibits may not be complete in the non-admitted emails. And the long and short of it is there is one email that I need to include either as a separate CTR exhibit, which probably makes the most sense. But what it is the La Quinta email. And the court may recall when the court gave a brief order in summary of the tendered Hotmail exhibit well before it was ever admitted, the court was concerned on hearsay grounds about an email related to a La Quinta reservations detail number, and there was a response from the defendant as part of that email, but there was a vast majority of that email was a La Quinta reservation, and that's what the court had some concerns on. Based upon that, we had redacted that La Quinta reservation, but left the defendant's non-hearsay statement, and that was the email that was tendered, but not the redacted La Quinta one. What we failed to do is we failed to put the original La Quinta reservation email in as a non-admitted exhibit, as a CTR-75 exhibit or whatever the next CTR exhibit is. So the long and short of it, Judge, is the only email that needs to be provided to the court in a CTR fashion is the original email that contained the La Quinta reservation information.
All right, why don't you just enter that email to my staff, and we'll just add it to the CTR exhibit that we already have.
Understood.
What exhibit number is that? 70? 73? Okay, so that's C-TR-73. We'll just add the La Quinta email to it.
Your Honor, may I approach your clerk, please?
You may.
Thank you.
That way will be a complete record of what People's Exhibit P-TR-347A was before it was modified.
Yes, Your Honor. And for the record, I did let Ms. Spengler know this as well.
All right, thank you.
Thank you.
All right, anything else before we get to the instructions? No? Okay, let's get to the instructions then. For the record, the prosecution submitted some instructions, and they were part of, I believe, was it P1? Was it P-122, the prosecution's jury instructions? 102? Okay, double check that, please. Whatever it was, the people submitted them. We'll double check on that just so the record is accurate. The defense submitted yesterday some tendered instructions. That was exhibit, or that was D-290. Exhibit A to D-290, I should say. And I have gone through the people's instructions and the defense's instructions. I did not have as much time to go through the defense's instructions because they were filed yesterday. And that's part of the reason why I took a little time this morning before I took the bench. I know we were supposed to start at 9, but I just thought it made sense to allow me to put together a draft that I can give you. So we have 3 drafts that we're working with. We have the court's draft, we have the prosecution's draft, and the defense's draft. So what I propose is that we go with my draft and we go one by one, and then we can address any issues that the parties want to address. Again, this is only an introductory session, and you're not waiving anything because you're not making any objections today, unless you say something specifically today that later, you want to contradict. But even then, if there's a reason for it, obviously I would allow you to do that. If you find out there's a legal basis for changing your position or there's some other reason, I will hear you out. So the first instruction that I have is, I'll mark it as instruction number 1 on my draft. This is the members of the jury instruction. It starts out with members of the jury instruction. I have made it consistent with the defense's instruction. I don't think it's inconsistent with the people's instruction, but the defense's instruction was more detailed in terms of including the advisement related to the jurors' conduct during deliberations. What I had initially thought about doing is just to continue to give them advisements the way I've been doing and modify them a little bit once deliberations start, but since the model instruction provides for an option at least to include those advisements specifically within this instruction, and since the defense drafted its instruction consistent with that and included a lot of details in terms of the admonishments that I've been giving the jurors, I went ahead and just did that. My changes, Ms. Nelson, are just to form. I made it so that it's easier to read. There are bullet points. I made it so that it's not repetitive. I think that there were a couple of things that I thought were repetitive, and so I have done that. One thing that I did change is in the model instruction, it tells the jury that if there's a conviction, I'm the one who's going to decide punishment. I deleted that because that's not accurate in this trial, so I took that out. I did not take out the sentence that says that punishment should not enter the jury's deliberations. Let me find the sentence. It says, in making your decisions, you must not consider punishment at all. That was not in the defense's instruction, and I really think it needs to be there. So I have put that in. That's a difference that I have with the defense's instruction. The other thing that I did is in terms of the admonishments, I divided them into 2. One, which is the admonishments that I have been giving them throughout the trial that continue to apply. And then the other group, which is 2 new admonishments that apply during deliberations. And that is, number 1, that if they have a cell phone or other electronic device, you must temporarily surrender it to my staff. You're not allowed to have a cell phone or other electronic device in the jury room during your deliberations. And second, or number 2, that you may discuss this case only when you are all present and only when you are in the jury room. No juror should attempt to discuss this case with another juror or other jurors except when all the jurors are present in the jury room. The other thing that I think I changed is that I made decision plural, because there's more than one decision they're going to be making. And for that matter, I wonder also if we should make verdicts, because again, they're going to be asked to return multiple verdicts. So are you okay, folks, if I make verdict plural in this instruction? Ms. Nelson?
Your Honor, that's fine.
Okay, I will do that. That is all I have with respect to that instruction. Is there anything else anybody wants to talk about, that anybody may want to talk about with respect to this particular instruction? Again, understanding that you haven't had a whole lot of time to review it, that I just gave it to you before I took the bench.
The only thing I see, Your Honor, is I don't know, do we really need these trademark symbols after iPhone, BlackBerry, Tweet, Facebook? I understand why people do that to protect their trademarks when they're publishing things, but I don't think we need that in a jury instruction.
I took that from the defense, but I agree with you that we don't need it. Ms. Nelson, is there any reason we have to have it?
Well, I think that was in the model instructions.
Okay.
Frankly, that's why we included it. It doesn't matter to us.
And I think I saw that in the model instructions too, but I'll take them out. I don't think we need them. All right. Ms. Nelson, anything else with respect to this instruction? Again, understanding that you barely had any chance to read them.
Yes, to be honest, I really haven't had a chance to look at it, but nothing further that I can think of right now,
Okay.
Your Honor. I just
All right.
reserve the right to make a further argument later if I need to.
Absolutely. And you have reserved that with respect to all the instructions, so there's no need to say it with respect to each. All right, the next one is the one I am marking as instruction number 2. And this is the one that talks about the charges. I think that mine is somewhat consistent with the defense's and somewhat consistent with the people's, but I think we all differ a little bit. I do like the way the defense did the charges in terms of saying the defendant is charged with 12 counts of murder in the first degree after deliberation, 12 counts of murder in the first degree extreme indifference, 70 counts of attempt to commit murder in the first degree after deliberation, 70 counts of attempt to commit murder in the first degree extreme indifference, and 1 count of possession of an explosive or incendiary device. I like that the defense specified the number of counts per type of charge. The people did not do it that way. However, the defense did not follow the model instruction, and I am following the model instruction other than the one change that I just mentioned. The people followed the model instruction. I'm going to follow the model instruction. What the defense appears to have done is that it split the instruction up into 2 instructions. And just so that the record is clear, I'm going to mark these instructions that the defense tendered by number based on the order in which they appear, if it's okay with everyone. So the first one that we talked about initially today, I will mark it as number 1. The next one, I will mark as number 2.
The only thing, Your
So
Honor,
on, yeah.
I'm sorry to interrupt. Before you do that, I seem to remember, and the reason I didn't give these numbers when I submitted them yesterday was that Ms. Spengler had submitted that proposed instruction about the model, and I thought we had marked that as defense tendered instruction 1, and so maybe that's why I was
true.
thinking this might be, the first one we submitted should be marked as number 2? I don't know.
That's true. You know, I'm just thinking ahead too. There may be another instruction that you tender before we get to these instructions, and so that may be confusing. I'm just trying to figure out a way to refer to the instructions so that the record is completely clear as to what I'm talking about.
I understand. We could refer to them by the titles that I assign them, or we could
You
start
assign-
with number 2.
Okay, let's refer to them by title. I didn't think about that. All right. So the ones that we're talking about now, in terms of the charges, the defense appears to have submitted 2 of them: description of charges and the charges against the defendant. And the model instruction calls for 1 instruction, and that's the way that I'm doing it. And so my number 2 reflects the way that I think it should be done. Anything from the people, Ms. Pearson?
One thing, Your Honor, and I got this, I didn't catch this either, is that all of the murder and attempted murder counts are in Arapahoe County. The possession of an explosive or incendiary device is actually in Adams County. So I think it should, after the attempt to commit murder in the first degree extreme indifference, comma, in Arapahoe County, and one count of possession of an explosive or incendiary device, comma, in Adams County. I think it should read that way.
What if we just take out Arapahoe County? I mean, we don't, it's in the state of Colorado. I'll just take that out. So it'll read in Colorado on or by July 20, 2012. Ms. Nelson, any objection to that? It's not an element of any of the offenses charged. The element that the people have to prove is that it was in the state of Colorado, in the state of Colorado, so.
Trying to remember if we made any arguments about, I seem to recall filing a motion about severing the explosives count, or there being an issue with the explosives count being in Adams County. I just don't want to waive anything, but I'm not going to take a position on that.
Okay.
I don't remember the number, but I do recall specifically the defendant did file a motion to sever that count, essentially change venue on that particular count to Adams County, which the court denied. But I don't think that makes a difference for purposes of this instruction. Your Honor is correct. The element that we have to prove is in the state of Colorado.
Right. All right. The people are okay with this change, and the defense is taking no position on it. So I'll just delete in Arapahoe County, and it'll just say in Colorado. Anything else with respect to this instruction on behalf of the people?
No, Your Honor. Thank you.
All right. Anything else on behalf of the defense, again, without waiving any future arguments? Ms. Nelson.
I think the other change, and I apologize, I don't think we have the body microphones at our table, so I apologize for my awkward
Oh, no, you know
posture.
what? Hold on. Let's just give you, let's make it easier because you're going to be talking quite a bit. So, well, hopefully not talking quite a bit, but frequently.
Do this one from the table mic, and then I'll put the body mic on. The only other change that we had proposed that's different than the pattern instruction is that I think we phrased it, the fact that Mr. Holmes, and we would ask the court to substitute the defendant with Mr. Holmes, because that is his name, has been accused is not evidence that he is guilty of any crime. I don't have strong feelings about he is guilty versus committed. But then we also included in that final sentence, or that he is sane. And because this is a case of not guilty by reason of insanity, we think that it's important for the court to include that language under Mr. Holmes's constitutional rights to due process and a fair trial.
Well, his name is Mr. Holmes, and that is undisputed, but he also is the defendant, and that too is undisputed. And to be consistent throughout, and to be consistent with the model instructions, I am going to stick with the defendant. In terms of adding the part about sanity, do the people have a position on that?
We do, Your Honor. The model instruction refers to it as sanity, and that's the legal term that you're going to see over and over throughout these instructions. And for consistency, we believe that that's how it should read, is with sanity.
I didn't follow that.
Oh, I'm sorry.
Yeah.
I know we normally have one person talking, but
It's fine.
Yeah, I'm sorry. I was looking at the wrong line, Your Honor. We would object to adding that. The language of Colgi is that he's been accused is not evidence that he's committed any crime, period. And I believe that that's what the language ought to read.
I agree. That's the model instruction. And also, it says in here that the defendant has pled not guilty by reason of insanity, which includes the plea of not guilty. And so I think that takes care of it. I don't think we need to add anything to the line about the fact that the defendant has been accused is not evidence that the defendant committed any crime. I think that's sufficient, especially given that later in the same instruction it tells the jury that the defendant has pled not guilty by reason of insanity, which includes the plea of not guilty. By the way, the part about which includes the plea of not guilty is something that both sides submitted, I think. And so given that both sides had it, I am including it. Next, I have my number 3, and my number 3 is the presumption of innocence, the burden of proof, and the definition of reasonable doubt. This is the model instruction verbatim. I think the prosecution's proposed instruction is consistent with the model instruction as well. The defense changed it a little bit based on the decision in People versus McBride, 228 Pacific 3rd, 216 Colorado Court of Appeals case from 2009. And so at the end of the first paragraph,
I can tell.
actually, it's the second sentence in the first paragraph. It reads, this presumption of innocence remains with the defendant throughout the trial and into deliberations. And so the defense added and into deliberations. But what the model instruction says is throughout the trial and should be given effect by you unless after considering all the evidence you are then convinced that the defendant is guilty beyond a reasonable doubt. So the defense's proposed instruction is a little different, and the title of the defense's proposed instruction is Presumption of Innocence, Burden of Proof, and Reasonable Doubt. Anything else on this instruction from the people?
Your Honor, the language that they're adding from McBride really had to do with how a prosecutor was arguing the case in closing. And so although this language is consistent with what the case talks about with regard to how something can be argued, it is not part of the model instruction. It is redundant. It is not necessary to express what the law requires with regard to the jury's finding, and we would object to including it.
Ms. Nelson, anything from you? Anything else?
Just to be, I think let's see if this helps. How's that?
Good.
Okay.
I can hear you.
Okay. Just to be clear, the proposed additional language includes the sentence following and into deliberations. So the defense also supplemented the instruction, the pattern instruction, with the following sentence: the presumption of innocence is only extinguished upon the jury's determination that guilt has been established beyond a reasonable doubt. I think that was also added into our proposal from the pattern instruction. We would, and this is similar to a change that we requested the court make to this instruction when the court gave the jury veneer initial instructions during general jury selection. And so we incorporate by reference all of the arguments that we made in support of this instruction at that time. I would just note that the pattern instructions are not binding on the court. We think that the proposed language that we have submitted is certainly consistent with the law. We don't think it's redundant because it makes clear that the presumption remains throughout deliberations, and we would ask that the court include our supplemental language based on Mr. Holmes's right to due process, fair trial, and fair and reliable sentencing proceeding.
It's true that the model instructions are not binding on the court, but they provide guidance. And this particular instruction from the model instructions is perhaps as cemented as any other. I mean, it has been around a long, long time, and I don't see a need to change it. There is also case law in Colorado that warns about the dangers of instructing the jury based on case law or based on anything that is part of the law. Just because something is part of the law doesn't mean the court should instruct the jury. It may be an accurate reflection of the law, but that doesn't mean that I should instruct the jury on it. And so I'm going to stick with the model instruction. There's no need to deviate from it. And so the tender instruction is rejected. Next, I have instruction number 4. My instruction number 4 is the number of witnesses. And this one is, again, verbatim from the model instruction. I believe the defenses is exactly the same, and so there's no disagreement there. I can't remember. I think the prosecution submitted an old version, so I'm going to stick with the current version from the model instructions. Anything else from the people on this?
No, Your Honor.
Anything else from the defense on this?
May I have just a moment?
You may, and the defense's title is number of witnesses. That's the title to the defense's standard instruction.
Nothing further.
All right. My number 5 is the credibility instruction, and the defense's title is credibility of witnesses. This is exactly the same as the model instruction. I don't think that there are any differences between what the people tender, what the defense tendered, and my draft, but I'll give the parties a chance to tell me if they believe that may be wrong. Mr. Orman, anything from the people, or Ms. Pearson, either one of you?
To us, Your Honor.
Okay. Ms. Nelson, anything from you with respect to this instruction?
No, Your Honor.
All right, thank you. That is a standard instruction. The next one I have is number 6 in my draft, and this is the expert witness instruction. The defense's standard instruction is titled expert witnesses. I believe that mine and the defense's and the people's are all the same, and they're all identical to the model instruction. Anything from the people with respect to this instruction?
A little different. I think that ours and the courts start with, you are not bound by. It looks like the defense's starts with, you have heard witnesses who have testified as experts, and I think that that may have been a change when they updated the model jury instructions in 2014.
All right, give me a second. I need to check this.
I can tell you, Your Honor, that we purposely took out that first phrase of the first sentence. We just felt like it wasn't necessary, and in a way may imply that, suggest to the jury that they should give expert witnesses testimony more weight than other witnesses. So we just thought that the instruction conveys what it needs to convey by simply saying you have heard witnesses who have testified as experts, and not including that you are not bound by language. I would even like it better if that were the last part of the instruction rather than the first part of the instruction, but it just struck me as sort of an odd way to start off an instruction, conveying to the jury essentially that they should treat expert witnesses just like any other witness. So that was the reason for our change.
Okay. All right, I stand corrected. There is a difference between my draft and the one proposed by the defense. And I am going to stick with my draft because my draft is consistent with the model instruction, and I'm not persuaded that there is any reason to deviate from it. So I consider what Ms. Nelson just argued, but I don't see that, I'm not concerned. So I'm going to go with the model instruction. All right, next I have number 7 in my draft. This is the direct and or circumstantial evidence instruction. The defense's standard instruction is titled direct and circumstantial evidence, no distinction. I believe that the defense's standard instruction is identical to mine, and mine is identical to the model instruction. The prosecution's standard instruction is different in that it omitted the examples given in the second and third paragraphs. I meant to ask you about that, but since the defense wants those examples, I am going to go with them. Anything that people want to say with respect to this instruction?
No, Your Honor, we don't object to that. I believe that the examples are bracketed in the model instruction, but we don't object to including them.
That's right, and that's why I had made a mental note to discuss it with you, but given that the defense has included it in its standard instruction, I am going to leave the examples in. And frankly, I think the examples are helpful to lay people, so I think it's a good idea to leave them in. Anything from the defense with respect to that instruction?
Not at this time, Your Honor.
All right, next in my draft is instruction number 8, and this is the limited purpose instruction. I don't know, Ms. Nelson, did you submit an instruction on this?
I don't remember off the top of my head, Your Honor, and if we didn't, we certainly would like the opportunity to propose one. I think I need a a moment to think about
I,
if there's
I,
anything we would want to add to the court's proposal.
yeah, I don't see one in your packet, so I don't believe you submitted one, but of course, if you wish to do that, I will give you an opportunity to do that, as long as you do it in a timely fashion. Do the people have anything on this instruction? It is exactly the model instruction.
It does not appear that we included one. We have no objection to this instruction.
And because we have admitted different evidence for different purposes, we can't give a specific one. Sometimes I've done trials where I give a specific limiting instruction saying, you'll remember that this particular evidence was admitted for this limited purpose. I'm reminding you again that that evidence can only be considered for that limited purpose. In this case, we've had different pieces of evidence, including testimony, for different or multiple limited purposes. And so I think it would be confusing confusing and dangerous to try to summarize it all into one. And I think the best way to proceed is to just give the generic, the more general model instruction. So, all right, next I have number 9 in my draft. This is the one that I read to Mr. Holmes a moment ago in terms of the defendant having a constitutional right not to testify. So let me find the defense's proposed instruction. The defense's proposed instruction is titled Testimony of Defendant Not Compelled. And it is a little different than my instruction. Do the people have any position with respect to this instruction? And again, I'm talking about number 9 in my draft.
Your Honor, we would propose using the model instruction.
Okay, and that's what I've done. Does the defense want to be heard any further on this instruction?
Just that we think it's important to include the language about sanity, given that this is a case that involves a plea of not guilty by reason of insanity. It may be an inference that the jury could draw, and there's clear case law from the United States Supreme Court that I cited in the proposed instruction, Wainwright versus Greenfield, that holds that this would be impermissible. So we would ask, under Mr. Holmes' constitutional rights to due process and a fair trial by an impartial jury, that the court give it as modified by the defense.
Do the people want to respond to that?
And, of course, Mr. Holmes' rights under the Fifth Amendment.
Your Honor, I think that the jury is going to be instructed in separate instruction as to what the elements are in order to find the defendant guilty. One of those elements is going to be the insanity element. So I think that the instructions include that within the concept of guilt, and therefore additional language in this instruction is not necessary.
I agree, and that was the same thing I was thinking as Ms. Nelson was making her argument. So for the reasons stated by Mr. Orman, which I agree with, the instruction tendered by the defense is rejected. Next I have instruction number 10. This is the instruction that addresses multiple charges and how a separate offense is charged against the defendant in each count of the information. I can't remember now if the defense tendered an instruction related to this issue, so let me check.
I can tell the court we did not.
Okay.
What we submitted was an instruction explaining, it's the multiple theories of first-degree murder instruction, page 16 of our tendered exhibit. I considered submitting an instruction like this. I think the prosecution submitted an instruction like this. But it's confusing because really the separate counts do refer to 2 different theories with respect to a single victim. We acknowledge that the law allows them to do so and allows them to do so as charged in separate counts. But I think it's sort of confusing to the jury to suggest that it's a separate and distinct offense, the after deliberation counts and the extreme indifference counts as they pertain to a particular victim. So we would ask the court to instruct the jury that they're pursuing multiple theories of first-degree murder in this case instead, because I think that makes it less confusing and not more confusing.
And so are you asking that I not give the model instruction and that I give instead the one that you submitted on the theories of liability that the prosecution is pursuing, which is titled Multiple Theories of First-Degree Murder? And maybe you submitted one for each type of crime that's charged. Did you do that? Actually,
I'm sorry, Your Honor, may I just have a moment?
yes. Ms. Nelson, I think you only submitted a multiple theories with respect to instruction with respect to first-degree murder. Multiple theories of first-degree murder?
Yes, that's right.
Well, don't you need to do it with respect to the attempted murder too?
I included, that's the title of the instruction, but the language of the instruction includes attempted first-degree murder. I just included both in the same instruction.
Oh, I see. Okay. So the title is a little off, but
Yes.
the instruction is broad enough that it includes both.
Yes.
Both types of crimes. Okay.
Your Honor, upon reflection, can I give you a first impression argument and then reserve the right to change my mind later?
Yes.
I think after briefly discussing it with Ms. Spengler, we would be all right with the court giving its instruction number 10, but we would also ask the court to give both this instruction as well as our proposed instruction on multiple theories.
All right. I think I would be disinclined to not give 10, but I might be persuaded to give both. And so let me ask the people. I did instruct the jury about the multiple theories at the beginning of the trial, and so I've explained that to them. Of course, that was a couple of months ago, and it'll be 3 months or so by the time, hopefully, we get to reading the instructions to them, but or at least 2.5 months, something along those lines. And so some time will have elapsed, and I don't know how fresh it will be in their mind. The multiple theories of liability instruction that we're talking about is not part of the model instructions. My initial reaction would be that counsel can address it during closing arguments. That's in part what closing arguments are for. And I am especially of that view, given that I explained that to the jury early on already. So I've told them about this. But if both parties want it, then I will consider it. And as I said, I may be persuaded to give something along the lines of the multiple theories instruction that the defense tender. Ms. Pearson?
Your Honor, we object to their instruction on multiple theories. I believe that this is something that should be argued in closing. It's redundant to Court's 10, but it also isn't accurate because it lists the theories and says you can find the theories are that he's guilty of first-degree murder after deliberation or attempted murder. Well, obviously, that's not accurate because it can be and it also doesn't even include anything telling the jury that they can find the defendant guilty of all of these. So it's a very incomplete and inaccurate instruction, and we object to it.
All right. As drafted, I am going to reject it. And frankly, even if it were accurate, I don't know that I would agree to give it. I think it's probably best that the attorneys address it in closing arguments. All right, 11 in my draft is that...
I'm sorry.
Yeah.
If I can just add, we would be willing to amend the instruction to include and/or, if that changes the court's mind.
It does not. I think given that there's an objection to it and given that it's not part of the model instructions, I think the best thing is for counsel to address the issue in closing arguments. That's in part what closing arguments are for. And both counsel can do it if they wish. So that instruction is tender. That instruction is rejected. And that again is the instruction from the defense that is titled Multiple Theories of First-Degree Murder. And I'm rejecting it not only because it is inaccurate, as Ms. Pearson stated, but also because it's incomplete, as Ms. Pearson stated, and also because even if it were accurate and complete, it is not part of the model instructions, and I don't see a need to give it because counsel can address it during closing arguments, and also because to some extent it is addressed in instruction number 10, and I want to make sure that we don't run into a situation where it may contradict something in instruction number 10, or that it may make something in instruction number 10 confusing. Instruction number 11 in my draft is the definitional instruction, and I don't know if the defense included a definitional instruction.
We did. It's titled Requirements for Criminal Liability, page 15.
Okay, yes. Actually, let me take a step back. I said that this was the definitional instruction in my draft. It is not. Number 11 is the culpable mental state instruction in my draft. And Ms. Nelson is right. The one she tendered that corresponds with my 11 is titled Requirements for Criminal Liability. Mine is exactly out of the model instruction. It is verbatim the model instruction. Ms. Nelson, does yours deviate from the model instruction?
Just in one small respect, which we noted in our comments at the bottom of the page, we removed the sentence in the definition of intentionally that states it is immaterial whether or not whether or not the result actually occurred. And that's just, from our point of view, a problematic sentence because we think that sometimes it can be material to intent whether or not a result actually occurs. Certainly that's been one of the theories that the court has been admitting, testimony about the various injuries that the victim sustained. So we just think that that sentence is confusing and also not completely legally accurate, and so that's why we removed it from our proposed instruction.
Well, it's the definition out of the statute, I believe, and it is also the definition out of the model instruction, so it is legally accurate. You may disagree with it, but I'm bound by the law. It's to the extent that there's disagreement, that's a disagreement with the legislature. I have to follow the law. So the tendered instruction is rejected on that ground. I have included the definition of recklessly. I know that people's tendered instruction did not include it, and whether we give the definition of reckless or not depends on whether I give the lesser included offenses that the defense is requesting. And I don't know whether the people have a position on those requested lesser included offenses. My understanding is that the defense is requesting that the court instruct the jury on the lesser included offenses of second-degree murder and manslaughter with respect to the first-degree murder counts, and that the court instruct the jury on the lesser included offenses of attempted second-degree murder and attempted manslaughter with respect to the attempted first-degree murder counts. So once I make that determination, then it may change this particular instruction. Anything else from the people on this instruction?
No, Your Honor, we would object to them deviating from either the law or the model instruction and taking language out of intentional.
All right. Okay, the next instruction in my draft is number 12, and this is the definitional instruction. Did you provide an instruction, Ms. Nelson, with definitions? I don't know that you did. I think you included some definitions within the elemental instructions.
That's what we did. We thought that made the most sense to include the pertinent definition with the elemental instruction when that was appropriate or necessary to do so, but we didn't submit a separate definitional instruction.
The definition of deadly weapon includes two things, one of which is a firearm, and then I have defined firearm here. The other thing that's included within deadly weapon is, and I'm paraphrasing, an object which is capable, which in the way it was used or intended to be used was capable of causing serious bodily injury or death. And again, I'm paraphrasing. And I had not included that whole definition in here. I was thinking more about that this morning, and I may actually include the full definition just to be safe, unless either side prefers that I not include it. Here's the situation. It seems to me that the 4 items in this case that could constitute a deadly weapon all fall within the definition of firearm, but all 4 could also fall within the other part of the definition, and I don't know that the people are limited or restricted to proving deadly weapon with respect to one definition or the other. So if the people want the full instruction, I'll provide it. And like I said, I was thinking about it more this morning and thinking that maybe I should do that. And perhaps one discussion that we should have before we even address the definition is, in terms of the sentence enhancing crime of violence count the people have filed, the people filed it as it relates to all the counts of first-degree murder and all the counts of attempted first-degree murder. And I haven't done any research on that, but it occurred to me this morning that perhaps we should look into whether it makes any difference, and maybe the people have looked into this and it does. It doesn't seem to make any difference with respect to any of the counts of first-degree murder, but it might or might not make a difference with respect to the attempted first-degree murder counts.
And the reason we did that is if there's a lesser included offense. So if they're convicted of, let's say, second-degree murder, I think it becomes more operative than if they're convicted of first-degree murder, which is either a death sentence or a life sentence. So that's why we need it for those counts, and that's why we filed it that way.
Okay.
Actually, Your Honor, you would need to have the deadly weapon on second-degree murder in order for it to be a crime of violence, so you don't end up with an 8 to 24 sentence range. So if they were to find a lesser of second. So we routinely add the crime of violence enhancers for any lessers from first. It will not matter for first-degree murder, but it could matter for anything underneath that.
I don't know that I agree with you on second-degree murder. It may matter on manslaughter, but it may be a per se crime of violence in terms of second-degree murder. But I haven't looked at that, so I'm just thinking out loud. But regardless, assuming that the people want it and it is given, the question then is, in terms of the definition, which definition do the people want?
Your Honor, I think we would ask to do the complete definition, just in an absolute abundance of caution.
All right, Ms. Nelson?
Your Honor, we would object to that, and I will explain why. And first, just to address the court's questions about the crime of violence sentence enhancement. I can't cite the specific statute, but I can tell you that I think you're right. Second-degree murder is a per se crime of violence, and I think manslaughter is not. But I'm not 100% sure on that. So, but that's how they pled it in count 142, and so that's why when we submitted our verdict forms, we included the interrogatory for all of the counts of first-degree murder as well as the counts of attempted first-degree murder. But I don't think that the interrogatory would apply to second or to manslaughter. And furthermore, in count 142, the reason that we object to giving the complete definition of deadly weapon for several reasons. The first is that they specified in count 142 that the deadly weapon they're alleging was used is assault weapon, shotgun, and handgun. So clearly it's a firearm, and we don't think that we need to be injecting definitions that don't apply to what they've pled into the case, especially because the complete definition of deadly weapon includes a discussion of serious bodily injury, and then the people's definitional proposed instruction includes then a definition of serious bodily injury. Now we're really getting into an area that we don't need to go with the jury. I mean, they were allowed to present some limited testimony of the extent and severity of the injuries, but the fact is that that's not an element of attempted first-degree murder, and I don't think that the instruction should inject this concept of serious bodily injury into the instructions for the jury if it doesn't need to be injected, because it's just confusing. So that's why they've pled it that way, and we would ask the court to give the instruction that just discusses the firearm. And I think that the most recent version of Colgy, the 2014 model instructions, gives two separate definitions of deadly weapon. I can't remember the number off the top of my head, maybe F88.
It is F88.
And so it's clear that it's meant to be, in some circumstances, one or the other, and I think it's clearly one and not the other in this case, so we would object.
Well, deadly weapon is defined now following the Colorado Supreme Court's decision in Montez, M-O-N-T-E-Z versus People, 269 Pacific 3rd, 1228, Colorado Supreme Court from 2012, as a firearm, whether loaded or unloaded, or a knife, bludgeon, or any other weapon, device, instrument, material, or substance, whether animate or inanimate, that in the manner it is used or intended to be used is capable of producing death or serious bodily injury. So I think that there are two possible definitions of deadly weapon. You can have it if you have a firearm, whether it's loaded or unloaded, and if it's a firearm and there's a definition of firearm, then automatically it's a deadly weapon. Or it can be a weapon that the prosecution proves in the manner it was used or intended to be used was capable of producing death or serious bodily injury. And I don't know that the prosecution is limited to one or the other. I think the prosecution can use either theory. There's nothing that says if it's a firearm, then you can only prove it under the first definition, or if it's a weapon that constitutes a firearm, the people can only go under the first definition, not under the second definition. So I think given that, I will give the full definition of deadly weapon. All right.
If I may,
Yeah.
while I'm thinking about it, the reason we put the interrogatories on the verdict forms is because my reading, and I may be completely wrong about this, but it was very confusing reading the new Colgies about what the verdict forms are supposed to look like, and it seemed to me that there's an awful lot of interrogatories on the new verdict forms under Colgie, and so that's the reason I put that in there, because it looked to me like that was required for first-degree murder, although that would never have been something that in the past we would have had on first-degree murder, an interrogatory for deadly weapon. So that's the only reason it's there right now, is that that's what I thought it was supposed to look like.
All right. And I haven't yet finalized the verdict forms. I've done some work on them, but I need to do more work on them. And I think in terms of the crime of violence count, we can address it through a single interrogatory that just asks if you find the defendant is not guilty of all the counts, then disregard this interrogatory. But if you find that the defendant is guilty of any one of these counts, then answer the following question or something along those lines. But I'm going to think about that more. Anything else that anybody wants to say with respect to the rest of the definitions in this instruction?
Your Honor, I would agree with the defense with regard to serious bodily injury, that we don't need that instruction or bodily injury in it at this point.
Well, if you don't want the definition of serious bodily injury, then I'm not going to mention the term serious bodily injury. So are the people asking me that I just give the definition of deadly weapon that is included within the first part and forget the second part?
No, I'm not saying that. I'm saying with regard to the additional instructions that we had put into ours, we'd included additional definitions for serious bodily injury. Bodily injury, we don't need to have those in this given the way we charged this case. But I would say within the deadly weapon definitional statute itself, I would ask that it still read the way the statute reads.
Well, but I can't do that. If I include the term serious bodily injury within the definition of deadly weapon, I'm going to have to define serious bodily injury and further bodily injury. So they go together. So either I just define deadly weapon as meaning a firearm, whether loaded or unloaded, and then that way I don't say anything about serious bodily injury or bodily injury, or I give the full definition of deadly weapon, in which case I have to define serious bodily injury and bodily injury. Those are the two choices.
Then I would choose the full definition.
All right,
including
then
those.
I will give the full definition, and I will also define serious bodily injury and bodily injury. All right, Ms. Nelson, anything else with respect to this instruction from you?
Nothing other than that we would just add, in relation to our argument that the prosecution had pled in count 142 that the deadly weapon they're alleging is clearly a firearm. We would just add Mr. Holmes's right to notice under the due process clauses of the state and federal constitutions, incorporate that into our objection.
Well, I don't think they mentioned firearm. I think they said handgun, shotgun, or assault weapon, right? Isn't that what the count
Yes, they
says?
did,
Right.
but those are firearms, Your Honor.
But those are also potentially an object that, in the manner in which it is used, or intended to be used, can cause serious bodily injury or death. So I think the defense was on notice. All right, the next instruction that I have is number 13. And here, when I received Ms. Nelson's proposed instructions, I was pleased to see that she was thinking along the same lines that I had been thinking. I didn't like the prosecution's proposed elemental instructions. And the reason for that is, on the one hand, it avoids having to give an elemental instruction for each and every one of the 165 counts in this case, or 164 substantive counts, which I appreciate. But on the other, I think it's dangerous because it could be confusing to a jury to give them one elemental instruction for a bunch of counts and then to say, after considering all the evidence, if you find the defendant that the prosecution has proven each element beyond a reasonable doubt, you should find the defendant guilty. That, I think, causes me concern in terms of having the jury think that if the elements are met with respect to one count, then all the counts have to be decided the same way, at least all the counts that relate to the same type of crime. The defense's instruction specifies in each elemental instruction the counts that are at issue. And I like that. I did it a little differently than they did, but the beginning of it I think is similar. So mine reads, the defendant is charged with murder in the first degree after deliberation in each of the following counts. And then it lists counts 1 through 12, and it identifies the victim listed in each count. Then it says, the elements of the crime of murder in the first degree after deliberation as charged in each of these counts are, that makes it clear that these are the elements for each of these counts, each of these 12 counts. Then I have the 7 elements. And then after that, in the last 2 paragraphs, it says, after considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt with respect to a count listed earlier in this instruction, you should find the defendant guilty of that count of murder in the first degree after deliberation. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt with respect to a count listed earlier in this instruction, you should find the defendant not guilty of that count of murder in the first degree after deliberation. By the way, the defense's standard instruction is titled Explanation of counts 1 through 12, and then a separate instruction, first degree murder after deliberation. So I have combined what the defense did in 2 instructions into a single instruction, and I think it makes sense to have it all as part of a single instruction so that it is clear that these elements apply to these counts that are identified. And the other difference that I have with the defense is the defense has not changed the 2 paragraphs at the end, and I think we should change them. What the defense did is it said this instruction pertains to counts 1 through 12 of the complaint and information. I think it's better to be more specific and clearer than that. Finally, the defense has added a paragraph at the bottom of this instruction that says, if you find that the prosecution has failed to prove element 7 beyond a reasonable doubt, you should find the defendant not guilty by reason of insanity. And that paragraph, in my view, is unnecessary. It is not part of the model instructions. It is an issue that is addressed elsewhere in the instructions, and so I'm rejecting that paragraph. But I think the other changes between the defense's standard instructions, the 2 that I mentioned a moment ago, And my tendered instruction number, or my draft instruction number 13, I think the other differences are pretty much as to form. Do the people have a position on instruction number 13?
Your Honor, we think this is an excellent instruction and that this should be the model instruction for doing this for multiple victims.
All right, thank you. Ms. Nelson?
Your Honor, we don't have any objection to the way that the court has combined our two instructions other than to maintain our position that the jury should be explained in plain language, and we don't see a downside to doing this, that finding that they haven't met elements 1 through 6 would result in a not guilty verdict, but that making the same finding with respect to element 7 would result in a not guilty by reason of insanity verdict. We think that's required under the due process clause and his right to a fair trial by an impartial jury under the state and federal constitutions. It's confusing to the jury, and I think this ties into the way that we have structured our proposed verdict forms, which are different than the way that the model instructions propose doing so in an NGRI case. The model instruction form, and which is what the prosecution based their verdict forms off of, has the jury finding not guilty or guilty, and then if they find not guilty, they go on to answer a special interrogatory about whether the not guilty verdict was based solely upon their finding the defendant was insane. And we think it's much clearer and simpler to just lay out the 3 different options for the jury, because really NGRI it's a different verdict, it has different consequences, and we think it's clearer and helps the jury conceptualize it better to just distinguish between those two.
All right. I actually think it would risk confusing the jury to do it the way the defense is proposing. I think it's better to do it the way the model instructions do it, and the way that I'm doing it is consistent with the model instructions. It will be completely clear to the jury, especially given that counsel can address this in closing argument, that if the only element that people fail to prove beyond a reasonable doubt is element number 7, then that means that the defendant is not guilty by reason of insanity. If the people fail to prove any other element, then that means that the defendant is not guilty. That will be crystal clear to the jury, and I'm not concerned, and I'm worried that if I include the paragraph in this instruction that the defense is asking me to include, which is not part of the model instructions, that it will invite or that it will risk confusing the jury, not make it clearer for the jury. All right, the next instruction is the instruction I've numbered in my draft as number 14. And this is the same type of format, but this is with respect to extreme indifference. And the defense's standard is titled first-degree murder, extreme indifference.
As well as the explanation of counts 13 through 24.
That's correct. There are 2 again, and I have essentially combined the 2 into 1, which I think is a better way of doing it. Ms. Nelson, you're not asking the court to give a definition of universal malice, is that correct?
That's correct.
All right, and the people are not either, correct?
I can expand upon our reasons.
No, Your Honor, I don't believe there actually is a definition for universal malice that's generally used.
Yeah.
There isn't one included in the new pattern instructions, Your Honor.
That's correct. But I know that it's defined in the case law, and I think there's a discussion of it in the comments to the instruction. But if neither side is asking for it, and I'm not inclined to give it, then it's not an issue. Ms. Nelson, you don't have to explain your position further unless you want to.
If we're all in agreement, Your Honor, then I'll decline that opportunity.
All right? Give me just a moment. comment number 6 to instruction 3-1:04 states, universal malice is not defined by statute. The above definition was developed through case law, and then it cites Candelaria versus People, People versus Jefferson, Longinotti, Longinotti versus People. Both sides are asking me not to define universal malice, and given that universal malice is not defined by statute, I will not give a definition of universal malice. All right, the next one I have in my list, or in my draft, is number 15, and this is attempt to commit murder in the first degree after deliberation. The defense has submitted 2 instructions titled Explanation of Counts 25 through 82, 143, 145, 147, 149, 151, 153, 155, 157, 159, 161, 163, and 165. And the next one is titled Attempted First Degree Murder After Deliberation. And my draft has the same format that I have discussed, and the only difference again that I see between the defense's instructions and mine are as to form, with one exception, the paragraph that we talked about, which the defense is asking that I give, which is, if you find that the prosecution has failed to prove element 7 beyond a reasonable doubt, you should find the defendant not guilty by reason of insanity. That is a paragraph that the defense, I believe, has included in every elemental instruction that it has tendered. And for the reasons I stated before, I am rejecting it. Anything from the people with respect to this instruction?
No, Your Honor, we think it's a good instruction.
Anything else from the defense, Ms. Nelson?
No, Your Honor, we just incorporate by reference our previous arguments.
Okay. Next is instruction number 16 in my draft. This is attempt to commit murder in the first degree, extreme indifference. Again, this is the elemental instruction, and same format that I have discussed. The defense submitted tendered instructions titled Explanation of Counts 83 through 140, 144, 146, 148, 150, 152, 154, 156, 158, 160, 162, 164, and 166, as well as the instruction that's titled Attempted First Degree Murder, Extreme Indifference. Anything else from the people with respect to this particular instruction in my draft?
No, Your Honor, and we have no objection.
Ms. Nelson, anything from you?
Not other than incorporating by reference our previously stated arguments. And this is number 16?
Yes.
Is that right? Okay.
Yes. Now, I don't have yet an elemental instruction for possession of incendiary device, and so bear with me. The next one in my draft is number 17, and this is the one on insanity. So let's skip ahead to insanity. And the instruction in my draft is consistent with the model instruction. The defense's standard instruction is titled Affirmative Defense of Insanity, and it's a little different than, or maybe more than a little different, it's different than the model instruction. And so, Ms. Nelson, why don't we start with you? And just so that you know, I have changed act to acts, actually not changed, but opted for acts in the plural in this instruction. And the model instruction gives a choice, either act or in bracket acts. I think it has an S in brackets to give the reader or the user an option of either using the singular or the plural. I think the defense's standard instruction uses acts as well. There's one place where I saw that the model instruction uses act in the singular, and does not give an option for plural, and that is in paragraph 1, where it says, he was so diseased or defective in mind at the time of the commission of the act to be incapable of distinguishing right from wrong with respect to that act. I think to be consistent, those should be in the plural as well. If we make it in the plural, my instruction has a typo. It should say those acts. But it should be acts in both places there in that paragraph. Do the people agree with that?
Yes, Your Honor, we do.
Ms. Nelson, do you agree with that? You may. If you prefer, Ms. Nelson, perhaps what we could do is change it so that it reads, the defendant was insane at the time of the commission of each act if he was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. In that case, then we could use singular as opposed to plural. I just think we need to be consistent to avoid confusing the jury.
Our position would be to keep it in the singular, which is consistent with the model instruction in the first prong of the model instruction.
Well, your tender instruction has acts in the second line, the second sentence. It says the defendant was insane at the time of the commission of the acts. So you're saying leave that plural, but then leave singular the use of act in the first in paragraph number 1?
No, actually, Your Honor, I think I'm saying we would propose changing our proposed instruction to make act singular. I just think that as a technical matter, the defense of insanity applies to each individual count charged, and
Right.
so
So what if we say each act? The defendant was insane at the time of the commission of each act if, and then go from there, and then we can use act in the singular.
that's fine with us.
All right, is that okay with the people?
It is.
Okay, that's how I'll do it. All right, Ms. Nelson, do you want to address the other changes that you made to the model instruction in your tender instruction?
Yes, Your Honor.
Not the other, but the changes that you made, I should say, in tendering your instruction. Just to, I'm assuming you want to make a record as to why you deviated in some parts from the model instruction.
Yes, Your Honor. There are two changes that we made to the model instruction. The first change was to, actually, I think there are three changes, I'm sorry. The first change was consistent with what we requested when the court gave the veneer instructions during general jury selection, group jury selection, which is to remove the language referring to moral obliquity and mental depravity, etc. We would incorporate by reference the arguments that we made earlier on that issue. We think it's confusing to the jury. It injects motive into the. I'm sorry, Your Honor. I'm just looking for. I had sketched out some arguments and I'm not finding them. If I may just have a moment.
Take your time. While she's doing that, Ms. Nelson is referring to the paragraph in the model instruction that reads, but care should be taken not to confuse mental disease or defect with mental obliquity, mental depravity, or passion, growing out of anger, revenge, hatred, or other motives and kindred evil conditions, because when an act is induced by any of these causes, the person is accountable to the law. This is a paragraph that is not only in the model instruction, but is also in the statute that defines the test for insanity in Colorado. And I remember the objection by the defense to that paragraph when I was addressing the jury, I think right after the jury was selected, and either there or right before the jury was selected during group jury selection. But I left the paragraph in the instructions that I gave at that time because it was consistent with not only the model instruction but also the statute. Ms. Nelson, did you find your place?
I didn't, but that's all right. I'll just proceed. So we think it improperly injects the issue of motive. It's not necessary. It's covered by other parts of this instruction, including the definition of mental disease or defect. And because it could be confusing to the jury, we would object to its inclusion under Mr. Holmes' state and federal constitutional rights to due process, a fair trial by an impartial jury, and a fair and reliable sentencing proceeding under the U.S. and Colorado constitutions. The second change we made to the model instruction, I think, is the language in red. Did the court get a color copy of our instructions? It's the 2 paragraphs.
I did. I don't have it with me.
Okay, that's fine.
But on my black and white copy, it shows lighter. So I can tell, but why don't you state for the record so that the record is clear what you're talking about?
So the 2 paragraphs that we added were simply, you have been instructed on the elements of each of the offenses charged in the complaint information, as well as lesser offenses that are included within those offenses. I have instructed you that the final element of each of those offenses is that the defendant was not insane. In order to meet its burden of proof with respect to that element of each of the charged offenses, the prosecution must disprove beyond a reasonable doubt both of the above numbered conditions. We think that just spells it out again for the jury and makes it clearer, and that's our basis for including that language. And finally, we added the last 2 paragraphs, which are, even if you determine that the defendant was not insane at the time of the commission of any of the offenses charged, you may consider all the evidence presented concerning his mental condition and assessing whether he acted after deliberation intentionally or knowingly at that time. The burden is always on the prosecution to prove each element of each charge beyond a reasonable doubt. If you find that based on all the evidence presented concerning his mental state and condition, the defendant did not act after deliberation intentionally or knowingly, and actually we should probably include recklessly if the court grants our request to instruct the jury on the lesser included offense of reckless manslaughter, then you must find him not guilty of the charges containing that element. Our basis, and I think I laid this out pretty clearly in our argument.
You did.
But our basis is the People versus Van Rees case, VANREES, Colorado Supreme Court case from 2005, as well as Hendershot versus People, HENDERSHOTT, which held that the defendant has a due process right to the jury, for the jury to consider and require the prosecution to prove each element of the offense beyond a reasonable doubt, including mental state, and that evidence of mental disease or defect or mental illness can be considered by the jury not only with respect to the affirmative defense of insanity, but also with respect to whether or not the prosecution has proven beyond a reasonable doubt the requisite mental state. So, and this also ties into our argument about lesser included offenses. I don't know how far the court wants me to go at this point, but this case is about mental state. And so we think that it's important to highlight to the jury that they can consider evidence of his mental illness in not just one way with respect to the affirmative defense, but also with respect to the culpable mental state here.
All right. And the argument that Ms. Nelson is referring to is at the end of the tendered instruction that's titled Affirmative Defense of Insanity. There's a section with a subheading of Argument in Support of Modifications Made to Pattern Instruction. All right, do the people have a position, Ms. Pearson, with respect to the 3 changes that Ms. Nelson highlighted?
Yes, Your Honor. With regard to moral obliquity in that entire paragraph, if the juror were not to be instruction, they would not be getting a complete advisement of what the law actually requires them to consider in the finding. It must remain. The 2 paragraphs that they wanted to include that are essentially redundant to both the paragraph above it and the paragraph below it in the instruction, because the jury is instructed that the prosecution has to prove beyond. And it tells them if we have failed to meet that burden, what we have. So the two paragraphs that they've added are simply, I don't know what their purpose is, but they're completely redundant. As to the last two paragraphs that they wish to add from Van Rees, essentially the defense is trying to say that pled not guilty by reason of insanity. It decided really it wasn't that he was insane, but you decide there's something else that's a lesser burden. We want you to still find him insane. That's essentially what they're trying to say here. And the statute clearly in 1995 combined impaired mental condition with insanity and made prong 1 and prong 2. Prong 2 is the old impaired mental condition, and the Van Rees is very clear about that. So they are instructed, in fact, to consider his mental condition and whether or not he had whether he had a mental disease or defect that prevented him from being able to form a state. And that is stated in the way insanity is charged in the statute with prongs A and B. But this is attempting to do something else with that and attempting to get the jury to use it in a way that would be improper and contrary to the statute. Van Rees dealt with an issue of defendant having mental slowness, which the court found did not rise requiring them to plead insanity, and therefore have a defense to not to charge in a way that not have in this case. The court clearly found the defendant's conduct rose to the level, his claim rose to the level of being mental illness that he had rose to that level to require a plea. Backdoor in an additional way to get the jury to consider insanity.
All right,
Respond?
sure.
I just want to make the record clear that our position, which I think is very clearly supported by the case law, is that there is a difference between Part B insanity and considering mental condition evidence for the purpose of whether or not the element of mens rea has been proven in any particular count. Part B insanity has to do with whether or not the defendant had the capacity to form the requisite mental state. And in Van Rees and Hendershot, and I think there's another case, Requejo, it's a Colorado Court of Appeals case. Those cases involved not whether the defendant had the capacity, which is Part B insanity, but whether the defendant did, in fact, under the facts presented, form the culpable mental state. So that's the difference. And I certainly don't think that just because Mr. Holmes has alleged or has asserted an affirmative defense of insanity, that precludes the jury from considering evidence of his mental illness and mental condition as it relates to the elements of the offenses charged. So that would certainly be a violation of his due process rights to preclude an argument or any kind of consideration by the jury of his mental illness as it relates to him actually forming, not having the capacity to form, but actually forming the culpable mental state. I would note that the definitional instruction for, I believe it's either intentionally or after, I think it's after deliberation, requires reflection and judgment. And as I said earlier, this case is, the crux of this case is about Mr. Holmes' mental condition. And a jury could properly find that his mental illness impaired, in some respects, his ability to reflect and have judgment. And if they find that the mental illness interfered with his ability to form, not his capacity, but his ability, actual ability, under the facts to form that culpable mental state, then that can be a basis for finding him not guilty of first-degree murder or finding him guilty of a lesser-included offense. So we think it's important. It's not crystal clear to the jury, I don't think, without these added paragraphs, that that's an appropriate way for them to consider the mental illness and mental condition evidence that's been presented in this case. And so that's why we think those two instructions are necessary, not only under his rights to due process and his right to a fair trial by an impartial jury, but also under his rights to a fair and reliable sentencing proceeding. We'd cite to Beck versus Alabama, as well as the Eighth Amendment and Colorado Constitution Article 20, as well as his right to present a defense under the Sixth Amendment and its Colorado counterpart.
All right, the paragraph related to moral obliquity, mental depravity, or passion, growing out of anger, revenge, hatred, or other motives and kindred evil conditions, is part of the paragraph, or is part of the model instruction. It also comes from the statute, and so this is part of the law, and it's part of the law on the test for insanity in Colorado, and so I am going to include it. There's nothing in the paragraph that is confusing. There's nothing in the paragraph that I think will mislead the jury, and none of the concerns that were raised causes me to change my mind in terms of including it within this instruction. The two paragraphs that are added on page 42 of the defense's standard instructions, and specifically it's on the first page of the affirmative defense of insanity instruction that was tendered by the defense, are unnecessary and potentially confusing. I agree with Ms. Pearson that they do little more than repeat what is stated elsewhere in the instruction or other instructions. And so I'm not going to include those two paragraphs. That's just a way of emphasizing a point that the defense wants to emphasize. While I understand the desire to emphasize, the defense is not entitled to have the same information repeated twice. Of course, in closing arguments, you're welcome to emphasize whatever points you wish, but I don't think it's appropriate to repeat the same thing in the instructions, especially within the same instruction, and some of the information in those two paragraphs is already stated elsewhere in this particular instruction. The final two paragraphs are also unnecessary because to the extent that they accurately reflect the law in Colorado, that law is included elsewhere in the instructions, but to the extent that they include anything that's inaccurate, then under the law, then it would be inappropriate for me to include those two paragraphs. I'm not excluding any argument by Mr. Holmes. There's not a request before me right now in terms of a motion in limine or in terms of a motion to exclude or to preclude any evidence or any arguments. And the only issue for me is whether the jury should be instructed on in a certain way. And these two paragraphs at the end of the tendered instruction from the defense are not part of the model instruction. So even if they are accurate under Colorado law, again, there's case law that cautions about instructing the jury on the law just because it's the law. You have to be careful about what you tell the jury. Just because something is the law doesn't mean I have to instruct or I should instruct the jury on it. We have tons of laws. We have tons of case law, tons of statutes. I can't and should not instruct the jury on all of it. And so what is appropriate is the model instruction. I think it makes sense to give it as drafted, and there's no need to deviate from it. So I will stick with my instruction with the exception of the change that I said that I would make in terms of the singular or plural of the act, the term act. All right, next I have instruction number 18, and this is, again, instruction 18 in my draft. This is the one defining incapable of distinguishing right from wrong. This is not in the model instruction, although the model instructions discuss this particular point in one of the comments. And it is an instruction that, without objection, I have given the jury already in this case. And so I think it's appropriate. Let me find the specific instruction in the model instructions where this is mentioned. It appears to be mentioned in comment number 3 to instruction I:01, and it says that the phrase incapable of distinguishing right from wrong is not defined by statute. In People versus Serravo, Serravo, the court provided the following guidance, and this was a case from the Colorado Supreme Court. A clarifying instruction on the definition of legal insanity, therefore, should clearly state that, as related to the conduct charged as a crime, the phrase incapable of distinguishing right from wrong refers to a person's cognitive inability due to a mental disease or defect to distinguish right from wrong as measured by a societal standard of morality, even though the person may be aware that the conduct in question is criminal. Any such instruction should also expressly inform the jury that the phrase incapable of distinguishing right from wrong does not refer to a purely personal and subjective standard of morality. So the instruction that I have drafted is very consistent with that comment, and specifically with the holding in Serravo, or the observation in Serravo. Do the people have a position on this particular instruction, Ms. Pearson?
Your Honor, we'd actually included that language in our insanity instruction, so no, that we have no objection to it.
All right, Ms. Nelson, you submitted an instruction to address this particular issue, and let me see if I can find it. Yes, it's titled Explanation of Incapable of Distinguishing Right from Wrong. It's similar to the one I drafted, but not identical to it. And there were a couple of differences that I noticed in your instruction from what Serravo observed or what Serravo said. One difference that I noticed was they used the word criminal and you changed it to illegal. I don't know if there were any other changes.
The two changes were the change from criminal to illegal and then the addition of that last sentence in our proposed instruction, the second paragraph, which states, a person may understand that his acts are against the law, but may nevertheless be insane because he is incapable of understanding that they are morally wrong. I changed criminal to illegal because I thought that was clearer and spoke to the evidence in this case and the way that the experts have talked about this issue. And so I thought, and Mr. Holmes' statements, and so I thought that was a change that would just be clarifying for the jury. We could also say criminal or illegal. Yeah.
Do the people have a position on that word?
We do, Your Honor. This is not this is a court of criminal law, not a court of illegal law. Criminal is a term of art, and I think that more accurately defines what the jury has to decide. They have to decide whether he committed a crime. And we believe that it ought to say criminal. We also do object to their second paragraph because, once again, they're trying to insert what would appear to be a personal and subjective standard of morality, which this instruction specifically states, as well as the Serravo case states, is not the standard.
And Your Honor, that's not the intention or the purpose behind that second paragraph. It's a clear and succinct explanation of what right versus wrong means in Colorado. And I know it's not in the pattern instructions. Again, the court's not bound by the pattern instructions. It's an accurate statement of the law. We wouldn't object to the court modifying that sentence slightly to, again, reinforce that it's a societal standard of morality. But I think there's a benefit to stating things in slightly different ways to the jury about important concepts, and this is one of the most important legal concepts in the case. If I may just have a moment.
Yes.
Oh. And Ms. Spengler is just reminding me that my reference to Mr. Holmes' statements in support of my argument about changing criminal to illegal, I just wanted to emphasize that Mr. Holmes' statements were admitted over our objections. We're not waiving any of those objections.
Right. All right. Ms. Pearson, you're objecting to the last sentence as well, right? To the second paragraph of the defense standard instruction?
Yes, I am, Your Honor, because I do believe that is attempting to, again, inject the personal and subjective standard of morality.
All right, I will think about that second paragraph. And also about whether it makes sense to use illegal instead of criminal. So I'll defer ruling on that. The next instruction that I have is number 19 in my draft. This is the informational instruction. The defense submitted an informational instruction. My informational instruction is consistent with the model instruction. And do the people have a position on my draft instruction, which is identical to the model instruction?
We believe that that is the instruction that ought to be given, Your Honor, and we do object to the defense instruction. Do you want me to explain some of my reasons why?
The defense's instruction is titled Informational Instruction on Commitment Procedure, and it is much lengthier and much more detailed, and it comes from not only the model instruction, but also several statutes. So, Ms. Nelson?
Yes, Your Honor. And we do acknowledge this instruction is much lengthier than the pattern instruction, and we think that's appropriate for several reasons. The first reason is that there were times during voir dire when the court frequently asked jurors to review paragraph 7 of the juror questionnaire, which contained this instruction, the pattern instruction, the language in the pattern instruction, and then asked the jurors if they had any questions about it. There were times when some prospective jurors asked additional questions and received additional information, and there were times when jurors didn't. And so I have to confess that I need to review in more careful detail the transcripts from the specific jurors who were actually ultimately selected in this case, but I think it came up with a couple of them. And we think that an expanded upon explanation would ensure that all of the jurors are given the same amount of information so that we don't have a concern where some jurors were given just what was contained in the questionnaire and other jurors were given more if they happened to ask questions about it during individual voir dire. So that's one basis for our request to expand this instruction. Secondly, I would note that under the case law holds that the entire purpose of this informational instruction is to avoid a possible miscarriage of justice where a jury would return a guilty verdict on the mistaken belief that as a result of an insanity verdict, the accused would simply be returned to the community. And in this case, our position is that the standard instruction is not sufficient to negate this possible miscarriage of justice because the pattern instruction really doesn't convey just how difficult it is and what the procedures are in order for someone to be released from custody following a finding of not guilty by reason of insanity. There is much more, obviously, to the commitment procedures than is conveyed by this informational instruction. And I would also add that the jury in this case has heard, they've seen, and they'll see more of this, but even at this point, the jury has heard evidence that Mr. Holmes is now on antipsychotic medication. They've seen videos over our objection of him talking to Dr. Reed and have been able to observe his demeanor and his thinking and his speech in those videos. And they have seen, at least in opening statements, and they will see more video and hear more testimony about his condition in November of 2012. He's obviously in much better shape than he was at that point in time. And I think our concern is that given the facts of the case and the evidence that the jury has been presented with and will be presented with, that they might think, mistakenly, that it would be very easy or that Mr. Holmes may be released from custody or from CMHIP into the community relatively quickly in the event of a not guilty by reason of insanity verdict. So the standard informational instruction, our position is that if that standard instruction were to be given in this case without further elaboration, it's insufficient to protect Mr. Holmes's rights to fundamental fairness, due process by a fair and impartial jury, under the 5th, 6th, 8th, 14th Amendments and Article 2, Section 16, 20, 23, and 25 of the Colorado Constitution. Section 16, 20, 23, and 25 of the Colorado Constitution.
Well, this informational instruction is interesting. I don't know that there is any other instruction in the model instructions or any other instruction that a court gives the jury in a criminal trial for informational purposes only. I think this is the only one that I'm aware of. And it's interesting because we give the jury the information and then we say, we're giving you this only for your information, but this cannot have any persuasive bearing on your verdict. So don't consider it basically as you are deliberating. And I think the Supreme Court in People v. Thompson, Thomson, was in a difficult situation. I think it had the concern that was discussed just a moment ago by Ms. Nelson. On the other hand, I think it was trying to figure out a way of having the trial court give the jury some information while at the same time telling the jury that the information could not affect the jury's verdict. I think the Supreme Court felt like it had to strike a balance between those two concerns. There was a concern that if you don't give the jury the information, that there may be a miscarriage of justice. On the other hand, if you give the jury the information, the jury may make a decision based on that information, and that too would be a miscarriage of justice. So the court had to, I think in the end, had to strike a balance between those two issues, and the court came up with a particular instruction that it believed was appropriate. And for a trial court, it is uncomfortable to second guess what the Supreme Court said. I am bound by what the Supreme Court says. I am bound by the Supreme Court's rulings. And I don't know that I would have come up with a better solution anyway. But even if I could, I can't just say, well, I know what the Supreme Court meant, but I'm going to say it better, or I'm going to say it differently. That would be presumptuous of me, and it would be improper of me. The Supreme Court was aware of the concerns and came up with this informational instruction and specifically said that trial courts, here's what the court said. The court said, recent studies and cases have recognized that today's juries are distracted from their fact-finding function by their concern that a defendant will be returned to the community at large if found not guilty by reason of insanity. A defendant who is relying on an insanity defense is entitled, upon request, to an instruction on commitment procedures. However, the court also directed trial courts to include the prefatory admonition that is set forth in the first paragraph of the model instruction. And so that's what I'm going to give. I do remember that there were some questions by some prospective jurors along the lines stated by Ms. Nelson. But you know, I was asking those questions when the prospective jurors were here in court, in open court, in front of the public, in front of the media, and they were being put on the spot. I would say, please read this particular paragraph in the questionnaire to yourself. And then I would ask them to put it down, and then I would ask if they had any questions. And some of them had questions because they wanted to know more specifics about this, or they wanted to confirm whether the court would make the decision as to whether the defendant is ever released from the Department of Human Services in the event that he's found not guilty by reason of insanity. Well, the instruction tells them that. And if they read it carefully, they'll see that it tells them that. I'm not as concerned now because when I give the jury the instructions, I'm going to give each juror a copy of the instructions. They're going to have it in writing, and they're going to be able to see that it says, if a defendant is found not guilty by reason of insanity, it is the court's duty to commit the defendant to the Department of Human Services until such time as the court determines that the defendant no longer requires hospitalization because he no longer suffers from a mental disease or defect which is likely to cause him to be dangerous to himself, to others, or to the community in the reasonably foreseeable future. So I think this is what the Supreme Court felt was appropriate, and this is what I'm bound by. This is an instance where the Supreme Court is telling trial courts, here's how you should handle this situation, and I don't have the authority to deviate from it and to say, I think it should be done differently. But I don't have the concerns that were expressed by Ms. Nelson in any event, because I think that if the jury reads the instruction carefully, they will understand that it's the court that makes the determination. Frankly, they don't even have to read it all that carefully. They just have to read it. And if they read it, and if they have time to read it by themselves without being put on the spot in open court in front of the public and the media, they will understand that the court makes the ultimate determination. Of course, counsel can cover this in closing arguments as well and can emphasize it and remind the jurors that it's the court that makes that determination. But again, this is an informational instruction only, and it tells the jurors here that it should have no persuasive bearing on the verdicts that they arrive at under the evidence. I am concerned also by the tendered instruction from the defense that it's so detailed that it makes it harder, it will make it harder on the jury to not allow it to have a persuasive bearing on its verdicts. You know, we're telling them, hey, we're giving you a little information here, but don't let it persuade you or have a persuasive bearing as you arrive at your verdicts. Well, the more information you give them and the more details you give them, the harder it is going to be for them to make sure that the information does not have a persuasive bearing on their verdicts. So I'm concerned about that too. I think that the point of the instruction that the Supreme Court ordered the trial courts in Thompson to give, or said that the trial courts in Thompson should give, was a brief instruction to generally explain to the jury that it is the court that makes that determination and that it should not allow that information to have any persuasive bearing on its verdicts. So I'm going to stick with the model instruction on this issue as well.
May I make based on that ruling, may I make an additional request?
Sure.
And I'd reserve the right to supplement my request later, but we would ask at a minimum that the court amend the model instruction language to include that it's the Colorado Department of Human Services, so that the jurors aren't somehow confused and think that it's like the Arapahoe County Department of Human Services or something like that. And that another issue that we actually, I don't think, addressed clearly enough in our proposed instruction, which we understand the court has rejected, is that the defendant will be committed to a secure mental health facility, namely CMHIP. So we would request that the court include a reference to that in the instruction. And finally, we would ask that the court consider adding language that makes it clear that it's the committing court. So it would be this court or a court in Arapahoe County that would make the decision sometime in the future about release, if that were ever to come to pass.
All right. Do the people have an objection to me adding the word Colorado before the Department of Human Services?
No, we don't object to that, Your Honor.
All right. Do the people have an objection to me adding the word secure before hospitalization?
Yes, we do. And again, that's just going down the path too much of telling them to ignore things that you're telling them about. And the fact is that the defense instruction only addressed the very last stage of conditional release and not all of the hearings before that where defendants get increased privileges that put them in the community. And so I object to anything that's sort of implying things that in fact aren't going to be true. So I don't think this should have the word secure in it. The state hospital can then give the defendant on grounds unsupervised privileges without ever coming before a court. And that's not a fenced facility. So the hospital itself is locked, but the grounds aren't. So it implies something different than is the in fact accurate.
Well, and I think by saying that the court has a duty to commit the defendant to the Colorado Department of Human Services, I think implies that this isn't just regular hospitalization, that he's not just going to a hospital the way a patient may be hospitalized. We're talking about a commitment. I think people understand the word commitment. I think lay people understand being committed to a hospital, to the Colorado Department of Human Services, and specifically a hospital within the Colorado Department of Human Services. So I don't think stating anything about it being secure is necessary. But I agree with Ms. Pearson. It is secure initially, but not necessarily throughout. And so I don't think that that would be completely accurate. And then to explain that further, again, would get into too much detail. How about the court for this court? Do you have any objection to changing that to this court, where it says until such time as this court determines that the defendant no longer requires hospitalization? I think this court would be accurate because it would be this court. Now, it may not be me, but it would be this court that would make that determination.
And the problem is, I think that that implies that it would be you, and that might not necessarily be the case. I think if you say it's the Arapahoe County District Court, that would be legally accurate, but I think this court implies that it's actually you.
All right. Are you okay with the Arapahoe County District Court?
Yes, without waiving our original request, Your Honor.
Okay, I will change that to the Arapahoe County District Court. All right.
And if the court's not willing to include language referring to a secure hospital, we would ask that the court include, I mean, the practical reality is he would be sent to CMHIP, and I think the court can say the Colorado Mental Health Institute at Pueblo, and be accurate there. And the jury has heard testimony from the experts about that facility, so we would ask that the court consider including a reference to CMHIP.
Do the people have a position on modify or adding the following, where it says to commit the defendant to the Colorado Department of Human Services, or actually we could do it to say to commit the defendant to the Colorado Mental Health Institute at Pueblo, which is within the Colorado Department of Human Services, or something along those lines.
I don't think that that's legally accurate, and the fact is I think they truly could send him out of state if they wanted to, but the commitment is to the Department of Human Services. And they determine the placement.
Does the statute refer to the Colorado Mental Health Institute at Pueblo?
I don't believe it does.
Your Honor, but I've never heard of anyone being sent anywhere else. So.
Well, I'm going to stick with the statute. So the statute says the Colorado Department of Human Services.
I'm sorry, it does say. What the statute says is the executive director of the Department of Human Services shall designate the state facility at which the defendant shall be held for care and psychiatric treatment. So we would ask the court track the language of the statute.
Yeah, I'm going to stick with the model instruction, not the model instruction, the instruction that the Supreme Court said that I should give. I don't have a problem specifying that the Department of Human Services we're talking about is the Colorado Department of Human Services. And I don't have a problem with specifying that the court that we're talking about is the Arapahoe County District Court. But I'm not comfortable getting into more detail about where exactly within the Colorado Department of Human Services or how the executor or the executive director, of the Colorado Department of Human Services can then choose the state facility where the defendant would go. You know what, I lost track of time, and I need to give Ms. Ficani a break, so I apologize for that. We've been at it for more than 2 hours, so let's go ahead and take about a 10 or 15 minute break. All right, the court will be in recess. Thank you.